In today's world, the amount of data that's stored with cloud providers is growing exponentially. And we need to find a way to give law enforcement access in accordance with the rule of law while protecting the fundamental freedoms and rights of customers and citizens. We think about the ultimate solutions that we need to build in this new era. We're going to need agreements between countries about how to make this work. And so we've reflected and tried to distill the basic principles of what we think are important to be reflected in that agreement. The first one is notice. A customer deserves to know when a government has accessed his or her data. Now, there may need to be very narrowly tailored exceptions because you don't want to interfere with an investigation, but those should be limited in scope and in time. Second, when demands are for sensitive data, email content or corporate business records, it's important that those be based upon independent judicial review. Third, cloud providers. We need to make sure that we're receiving appropriate information so we can make sure and double check that this order has been properly adopted. Fourth, it's important that international agreements deal with the potential of conflicts of law. Currently, the United States has a statute that says we are not permitted to disclose data stored in the United States, even if it comes from a lawful order from a European court. Now, we need a system that's going to work and reconcile those conflicts so that it's a system that that doesn't put anybody in an obligation to violate one country's law to comply with the others. Fifth, we need a modern rule for dealing with enterprise data. As enterprises, whether governments or civil society or businesses, move their workloads and data to the cloud, the same protections they had storing that data in their own data center should apply, and law enforcement should go to the enterprise and not to the cloud provider when it has an order for their data. Sixth, it's important to have transparency around how and how often governments are using these. We think that the public has a right to know because this is a fundamental question about the government using its power to seek private information that is protected and subject to fundamental rights. Some of the hardest work is going to be, frankly, in Brussels and the national capitals as national governments try to sort through what's a common approach that can be accepted across Europe. But I feel good about the evidence proposal that the Commission's put forward. It's going to be up to the Council of Ministers and the national governments to decide if they want to make adjustments, and then also for the European Parliament, our elected officials, to decide how they want to ensure that fundamental freedoms are protected. Then the next step is also that US-EU agreement and ensuring that that agreement is done in ways that respect Europeans' fundamental rights and Americans' constitutional rights. And I think that is the solution that we all want.